Antitrust confronts the challenge of 21st century technology, revisiting United States v. Microsoft Corp. A program planned and developed by the Historical Society of the District of Columbia Circuit, with video produced by the Federal Judicial Center, June 7, 2023. Douglas Melamed, scholar in residence at Stanford, sets the stage, followed by a reenactment of the argument before the D.C. Circuit, led by Kristen C. Lamarzi of Gibson, Dunn & Crutcher, LLP, and David I. Gelfand of Cleary, Gottlieb, Steen & Hamilton, LLP, with Judges Douglas H. Ginsburg and David S. Tatel of the United States Court of Appeals for the District of Columbia Circuit presiding. The program includes a panel discussion moderated by William Baer, visiting fellow of the Brookings Institution, with Professor Melamed, Maureen K. Olhausen, partner Baker Botts LLP, and David C. Frederick, partner Kellogg Hansen Todd Feigl and Frederick, PLLC, along with Judges Ginsburg and Tatel.
Good afternoon. I am Jim Rocap, the president of the Historical Society. I'm very happy to welcome the judges of our courts who are in attendance. Chief Judge Postberg, thank you very much for attending, as well as the other judges, and the many law clerks and court staff who are here, and all of you who have joined us this afternoon. This is the 24th program presented by the Historical Society since it was founded in 1990. In 2019, the Society named the series the Judge Patricia M. Wald Programs on Life and Law in the Courts of the D.C. Circuit to recognize Judge Wald's extraordinary contributions to the Society's programs over the years. And this is the second program in the renamed series. So our topic today is antitrust, and in particular, the 2001 decision of the Court of Appeals in United States v. Microsoft Corporation. And we are honored to have Judge Douglas Ginsburg and Judge David Tatel as participants in the program this afternoon, as they were also members of the en banc court in 2001 that issued the Microsoft opinion. So our program this afternoon is going to proceed in 3 stages. First, the stage will be set by Doug Melamed. Doug is currently a scholar in residence at Stanford Law School. He's on the screen over there. And among other things, was a former partner and chair of Wilmer Hale's Antitrust and Competition Practice Group. Particularly relevant today in the years leading up to the Microsoft case and the decision, he served as the principal deputy assistant attorney general and then the acting assistant attorney general, and was a principal author and the final editor of the legal papers filed for the Department of Justice in the Microsoft case. Second, we will listen to a reenactment of the arguments, or a portion of the arguments, on the principal substantive issues in the case. The arguments will be presented by 2 highly respected, outstanding advocates in the antitrust field. First, Kristen Lamarzi, a partner at Gibson Dunn, and formerly a top enforcement official at the U.S. Department of Justice's Antitrust Division. Second, David Gelfand, currently at Cleary Gottlieb, and a professor at Arizona State Law School. And from 2013 to 2016, Dave was the Deputy Assistant Attorney General overseeing litigation in the Antitrust Division. And Judge Ginsburg and Judge Tatel, who need no introduction, will preside over the argument. And finally, Bill Baer will moderate a panel discussion on both the historical aspects of the decision as well as its continued vibrancy and impact today on antitrust law and enforcement. Bill is the former director of the Bureau of Competition of the Federal Trade Commission and former Assistant Attorney General of the Antitrust Division at the Department of Justice. He is now a visiting fellow at the Brookings Institution. Joining the panel will be David Frederick, currently a partner at Kellogg Hansen here in DC, who in 2001 was an assistant to the Solicitor General, and relevant here, was one of the 2 government attorneys to present argument to the court on behalf of the United States in the case. And also Maureen Olhausen will be joining the panel. She is currently the chair of Baker Botts' Global Antitrust and Competition Practice and formerly the acting chairman and a commissioner of the Federal Trade Commission. So we have a dream team to hear from this afternoon. Finally, there will be a reception in the Bryant Annex Atrium on the first floor following the program, which will conclude as close to 6 o'clock as we can, and then the reception will follow. So please join us if you have the time and inclination. So as I mentioned before, Doug was on Zoom. He was prevented at the last minute by some unforeseen circumstances from joining us in person, but he is here through the magic of Zoom. So Doug, I'm going to turn it over to you.
Let me say at the outset that I do apologize that I'm unable to travel and therefore can't be there in person, but we'll make the best of it. All right, the government's antitrust case against Microsoft was very controversial when and after it was filed in 1998. It was the first monopolization case filed by the federal government in more than 20 years. It raised a multitude of conceptual and legal issues that had not been resolved and in some instances had not arisen previously. And it was the first confrontation between the antitrust laws and the new world of digital technology. Microsoft was founded in 1975. IBM developed the first commercially viable personal computer 6 years later. Microsoft's MS-DOS soon became the dominant operating system for PCs. In 1983, Microsoft introduced the Windows operating system, an extension of MS-DOS that included graphical user interface and enabled users to use multiple unrelated applications simultaneously. Microsoft Office, a suite of spreadsheet, word processing, and PowerPoint applications, was released in 1989. All of these applications and operating systems were for use on the user's PC itself. By the late 1980s, Microsoft's share of the relevant computer operating system market was more than 90%. By the mid-90s, it was more than 95%. In June 1992, President Bush awarded Microsoft's founder Bill Gates the National Medal of Technology in recognition of his early vision of universal computing. A few months later, Fortune magazine named Microsoft the most innovative company in the United States. By January 2000, Microsoft was the world's largest company, with the possible exception of number 9 Intel, which is in many respects more of a manufacturing company. None of the other companies in the top 10 was a technology company. By contrast to today, in which the 5 biggest firms in the world other than Saudi Aramco are all familiar technology firms, in the late 1990s, Microsoft stood alone. I think it's reasonable to say that the story I just summarized was at the core of Microsoft's vision and that it informed in important ways Microsoft's approach to the Justice Department's case. It was a vision of innovation and entrepreneurship and creation of real value, not just for Microsoft and its shareholders, but for the world. And the belief that if Microsoft were restrained by the antitrust laws, the path of innovation and creation would be distorted and diminished. The Justice Department had a different vision. It did not paint with so broad a brush. It focused instead on specific aspects of Microsoft's conduct that it believed interfered with the ability of Microsoft's competitors and potential competitors to innovate and create. The government's concerns were prompted by complaints about various practices that allegedly handicapped Microsoft's rivals. During its investigation, the government came to believe, and the court subsequently found, that Microsoft's dominant position in operating system market was protected by what the government called the applications barrier to entry. The idea is this: operating systems have value only if they enable users to access and use applications like word processing or video games. Applications work only if they are written to be compatible with the interfaces, the so-called APIs of the operating system. As long as Windows was the dominant operating system, developers would write their applications to work with Windows, because that would give them access to the largest universal potential users. Some might later write a version of their application for other operating systems, but many would not. As a result, Windows would always have access to many more applications, and users choosing between competing operating systems would prefer Windows for that reason. In the 1990s, some economists were calling this phenomenon a network effect. to connote the idea that a large network of both users and applications is needed in order for the system to succeed. Today, the idea of network effects is almost universally accepted and commonplace. In the 1990s, it was novel and hotly contested. A company called Netscape introduced the first commercially successful internet browser in 1994. Microsoft developed and released its own browser, Internet Explorer, in 1996. Internet Explorer was included with Windows in the same software that Microsoft distributed to computer manufacturers. In the court litigation, the government discovered a memorandum from Bill Gates to his executive staff dated May 15, 1995. Gates described the internet as an inflection point, the most important development since the PC. He said, quote, "A new competitor born on the internet is Netscape. Their browser is dominant, allowing them to determine which network extensions will catch on. They are pursuing a multi-platform strategy where they move the key API into the client, the browser, to commoditize the underlying operating system. In other words, by enabling a migration of the critical application interface function from the operating system itself to the browser, which could run on any operating system, and thus giving applications access to all operating systems, and giving users of all operating systems access to the applications, Netscape might eliminate the application's barrier to entry and turn operating systems into low-value commodities with multiple competing suppliers." That memorandum aided the government's articulation of the theory of the case. Microsoft engaged in a variety of actions, including product design and restrictions imposed on computer manufacturers and other distribution channels for browsers, that prevented Netscape and other potential platforms from becoming so widely used that they might displace Windows as the interface with computer applications and thus open the operating system market to competition. By these actions, the government alleged, Microsoft was trying to maintain its operating system monopoly in violation of Section 2 of the Sherman Act. The big question in the case was whether Microsoft's conduct crossed the line between lawful competition on the merits, by, for example, product improvements and cost reductions, and unlawful anti-competitive conduct that excluded competitors without providing such benefits. In 1997, pollsters found that Microsoft was the most admired company in America. Subsequently, however, stories of Microsoft's aggressive conduct in the government's investigation reached the press. There was a bit of a frenzy, fueled, I think, by Microsoft's meteoric rise, its perceived position as a gateway to the new age of information technology, and a not inconsiderable degree of envy about the fact that Bill Gates, barely 40 years old, was worth more than $40 billion. And back then, Microsoft was the only consumer-facing tech giant. Public opinion turned. Writing in 1998, New York Times columnist Maureen Dowd called Gates a rich, spoiled brat who has not yet realized that people hate Microsoft even more than they hate the government. The government filed this complaint in May 1998. The core of the complaint was the allegation that Microsoft had engaged in a pattern of anti-competitive conduct that excluded platform threats like Netscape and thereby preserved Microsoft's operating system monopoly. The filing of the complaint and many of the subsequent developments were front-page news around the country. A courtroom was packed every day, largely with reporters. The case expeditiously focusing on liability. The district court, Judge Jackson, issued his findings of fact in November 1999, but he deferred the conclusions of law and instead appointed Judge Richard Posner to mediate the dispute. The parties failed to reach agreement on settlement, and Judge Posner terminated the mediation. Judge Jackson issued his conclusions of law in April 2000. It was an overwhelming victory for the government. The government subsequently filed this proposed remedy, basically breaking Windows and Office into two separate companies. Microsoft filed a reply, and Judge Jackson granted the government's request without discovery or hearing on remedy issues. Microsoft appealed. The Court of Appeals decided sua sponte to hear the case in bank. The government's brief as respondent was due in mid-January, just a few days before the inauguration of President Bush. an inauguration that entailed the replacement of the senior political folks in the antitrust division with a new team from a different political party. The oral argument in which the government was represented by two outstanding holdover lawyers from the SP's office spanned 2 days in February 2001. The DC Circuit issued its unanimous per curiam en banc decision in June 2001. It was a substantial victory for the government on liability. The court remanded on remedy, and the parties ultimately entered into a consent decree. The reenactment today will focus on 2 of the many legal issues in the case. It will assume that Microsoft had monopoly power in the relevant operating system market. The first question concerns one of many aspects of Microsoft's conduct that the government alleged were anti-competitive. Was the integration of Microsoft's browser into the Windows operating system anti-competitive conduct for purposes of Section 2 of the Sherman Act? In other words, did the integration handicap Netscape's competing browser by preventing computer manufacturers from pre-installing Netscape and making it harder for users to use it? And if so, could those harms be justified by product improvements or other benefits created by the integration? The second question concerns whether Microsoft's anti-competitive conduct was shown to have a sufficient impact on the market to violate the antitrust laws. Can the government establish a violation of Section 2 simply by showing that a monopolist engaged in anti-competitive conduct that had the purpose and effect of raising entry barriers in its market, without identifying the particular operating system competitors that have been or will be excluded? And with that, Jim, let me turn it back to you.
Thank you very much, Doug. So we're going to go to the second phase now. We will not keep you here for 2 straight days, which is how long the first argument took, but we've asked both Kristen Lamarzi and Dave Gelfand to limit themselves to 10 minutes. And we're going to start first with Kristen. Thank you.
Good afternoon, Your Honors, and may it please the Court. Kristen Lamarzi, channeling Richard Urofsky on behalf of Microsoft. For nearly a century, since Standard Oil itself, the Supreme Court has held that the mere possession of monopoly power does not violate the Sherman Act. To the contrary, a firm that achieves monopoly through superior skill or industry ought to be rewarded in our free market system. In this way, the antitrust laws protect the very competition that spurs innovation and ultimately improves consumer welfare.
Am I correct in thinking that the government doesn't dispute that Microsoft achieved its monopoly lawfully?
Correct. That's our understanding.
So we're talking not about achieving it, but about maintaining it unlawfully.
Maintaining it, exactly. But I think in this case, Your Honor, the government's case turns those bedrock principles that the maintenance of monopoly power through continued innovation, skill, product improvement, those are bedrock principles in our antitrust laws. And the government's case instead weaponizes the antitrust laws to punish product improvements and stifle innovation. And I think I'd like to focus today on two.
But the question still is whether, I mean, you're right about that, but the question is whether Microsoft engaged in anti-competitive behavior, right?
Yes.
That's the question. And according to the record that I've read here, there were users who wanted to uninstall Internet Explorer. Like Gateway specifically tried to do that, or asked Microsoft to, and Microsoft said no. So, I mean, what possible pro-competitive reason is there for that?
Well, I think before you get to pro-competitive reasoning, the conduct has to actually foreclose competition. And in this case, I think the
Judge Jackson actually found that it harmed Netscape's business, right?
But it does not deny Netscape a route to market. It does not prevent Netscape from distributing its product to consumers. Anyone with an internet connection can download Netscape and use it.
Is it your position that Section 2 requires complete exclusion from the market?
No, but where rivals have substantial other means of distribution, there is no exclusionary conduct. And I think the leading case on this point is Omega Environmental in the Ninth Circuit. The plaintiff in that case claimed the defendant had exclusive control over the most desirable means of distribution, but the Ninth Circuit rejected that as a matter of law, finding there was an ability on the part of plaintiff to distribute directly to consumers, as well as to develop alternative distribution measures, and all of that, as a matter of law, meant that the claim could not be allowed. Those are the facts we have here. Netscape has many means of distribution, including direct to the consumer through a click of a button.
The government has identified, and Judge Jackson found several channels of distribution, I think 5, that were substantially or completely foreclosed from Netscape. Right? So if the alternative that was left to them was so adequate, what was the point of deriving all these exclusives to keep Netscape out of all the other channels?
Well, I would say that the purpose of the product integration that Microsoft engaged in was indeed to improve the product. And Judge Jackson acknowledged that many, if not most, consumers can be said to benefit from Microsoft's provision of web browsing functionality with its Windows operating system. And the integration did have the purpose and effect of making the product more attractive to consumers and making the product more attractive to developers, adding functionality to the operating system and the web browser and increasing usage. But that is competition.
Doesn't that make it even more surprising that Microsoft would have taken these steps to foreclose other channels? If people would prefer the integrated browser, what's the purpose of trying to exclude an alternative from the consumer?
Because by driving developers to build applications on their system, Microsoft could continue to improve the quality of its product and continue to draw users to that.
And would users moving to use Netscape instead diminish anything of what you said about the benefits of integration?
I think that the goal was whether or not there were attendant effects on fewer consumers choosing Netscape. That nevertheless wasn't the purpose and effect of the integration, and to hold that Microsoft had to leave open, not just leave open means of distribution, but facilitate the distribution of the Netscape browser on its operating system, I think is contrary to the law. As Judge Posner explained in Olympia Equipment Leasing, a firm with lawful monopoly power has no duty to help its competitors by pulling its competitive punches. I think that's the circumstance you would have here.
You say that, I want to go back to an earlier point you made. Your argument is that bundling Internet Explorer into the operating system was not anti-competitive because it improved the product, right? That's your point. But Judge Jackson didn't fault Microsoft for bundling. He focused on these 3 specific things that Microsoft did to bind Internet Explorer to the operating system. By removing it from the add removed utility, intermingling the code, and causing Internet Explorer to open even when it was a default. That's what he found. And he found that those 3 aspects of Microsoft's behavior were anti-competitive. That's his point. And what's our basis for upsetting that decision?
Well, I think we've challenged in our briefs, Your Honor, that Judge Jackson's conclusions, particularly about integrating the code, are clearly erroneous.
Yeah, but I agree. Excuse me, but yes, I agree with you about that. But what about the first 2? There's nothing in your brief about either of those. At least I didn't see it.
Well, Your Honor, I think
are they essentially conceded about the commingling of the code?
I understand, Your Honor. I think our argument is twofold.
Well,
One,
what about the point that am I right about the brief that you don't really argue that, right?
That may be
either
true,
of those
Your
points.
Honor.
Yeah, right. That's not there. So is that conceded?
I think there are 2 reasons why that those findings, to the extent we could call them findings by Judge Jackson, don't yield a finding of liability here. One is going back to, removing Internet Explorer from the add remove button doesn't prevent consumers from using Netscape. It doesn't prevent Netscape from distributing its product. So before we get to whether or not there's a pro-competitive justification for that move,
it just makes
we
it
have to
more
conclude
difficult.
this. But again, as Judge Posner said, in Olympia, that is not our duty. That is not our obligation to make it easier for consumers to use competing products.
This is the DC Circuit.
Yes, Your Honor, it is. Your Honor, I want to make sure that we spend a little bit of time on the causation issue as well, and I'm about at 8 of 10 of my minutes, so if you don't mind, I'll move there. So even if the district court were correct that Microsoft's conduct foreclosed Netscape's web browser, that's a far cry from maintaining monopoly in the separate operating system market. And here I think it's really important to level set on what the government's actual claim is. For present purposes, at least, the claim is not that Microsoft maintained a monopoly in the web browsing market by excluding a web browsing rival. Instead, it's that the government claims Microsoft had a monopoly over operating systems, and somehow by restricting Netscape in the web browser market, it was illegally protecting its operating system market. But the government bears the burden to prove that Microsoft's behavior contributed significantly to the maintenance of its monopoly. And the government's theory on how that would take place in this case is quite tortured, I would say. Absent Microsoft's conduct, Netscape would develop Navigator into a platform with features that would enable developers to write full-fledged applications that don't exist today and don't rely on the underlying operating system. And they would write so many of those that that it would create a viable market for these low-level operating systems in which Netscape and others would enter, and that would threaten Microsoft's monopoly in Windows.
Do you agree? Is this statement accurate about the record that that Microsoft itself, its own internal documents showed it viewed Navigator as a threat, right? A competitive threat, correct?
Yes.
Why isn't that powerful evidence of causation? What more do you need?
Well, I think it's undoubtedly evidence of something, but this isn't a subjective test. Paranoid firms don't face different legal standards just because they're paranoid. The question before the court...
That's a good line for our opinion. I like that. That's excellent.
The question before the court is whether through this tortured series of events, Netscape's web browser was a reasonable threat to the operating system. And here, the district court found there was, quote, insufficient evidence Netscape could develop in this way. It, quote, remains to be seen whether there will ever be full-fledged applications written for middleware. It's, quote, not clear there would be the sort of breadth and diversity of applications to support a market. And there's no evidence that Netscape had the plan to do this in the first place. So based on that record, I don't think it's reasonable to say that Netscape posed a reasonable threat to Microsoft's monopoly. And absent that, any action that Microsoft had taken to disadvantage, or I think more accurately to compete against Netscape's web browser cannot constitute monopolization under Section 2.
Is it correct that one of the documents, or maybe the principal documents to which Judge Tatel referred, was the document in which the president of the company, Gates, says to his employees is concerned that middleware in the Navigator could be developed into an operating system. Is that one of the documents we're most concerned with here?
Yes,
Yeah.
That's an internal Microsoft document. And but as I say, I think a chain of causation that relies on a series of events, each one reliant on potential actions by myriad unnamed and independent market participants that may someday help to shield Microsoft from new technology that might threaten its operating system, I don't think as a matter of law meets the causation requirements, meets the government's burden to establish causation in its case, notwithstanding Mr. Gates's speculation.
Well, the government also has, from Judge Jackson, I believe, 5 series of findings regarding the 5 media of distribution that were foreclosed, correct? So each of those represents what was found to be an anti-competitive act. Right? And you're saying the cumulative effect, or I should say even the cumulative effect of those anti-competitive acts could not sustain the inference that not only the purpose but the actual proven effect here was anti-competitive.
Yes, Your Honor. I don't think you can infer exclusionary conduct had an effect on nascent competitors in this case, because I don't think you can credibly call
Okay,
Netscape
so what
a
should the
nascent
government
competitor.
have had to prove?
That the Netscape posed an actual threat to its operating system monopoly.
And
What
what
sort
do
of
you
evidence
what do you cite for that?
I think
What's
there
the authority for that?
would have required additional
No.
evidence
Is
about.
there any authority for that, what you just said?
Oh, that
Yeah.
the causation?
Right. That-
I think that
there has to be
the,
evidence that it posed, didn't you say an actual threat?
I did say.
Okay, so what supports that? I mean, what do you cite for that?
So I should clarify, Judge Tatel. When I said actual threat, I did not mean to imply that Netscape needed to be present in the market. I certainly think that Section 2 can reach conduct which is designed to thwart nascent threats.
And why isn't the
But-
government's evidence, the district court's findings sufficient to meet that burden?
Because it relies on not just unfounded, as it turns out, it's supposition that Netscape is planning this, but that they would be able to develop the technology to build the platform, and then that hundreds of third-party developers would come in and build the sort of infrastructure that would be required to create this market. And then that Netscape, who has no plans, would pair with Sun to create the low-cost operating system.
Okay, thank you.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. My name is David Gelfand, and channeling David Frederick, I represent the United States in this case. The stakes in this litigation could not be more enormous. There are 180 million personal computers in America, and that number grows by tens of millions each year. The way we work, the way we do business, the way we play, the way we create, and the way we communicate with each other has been forever revolutionized by these devices. Personal computers have provided us a gateway to the world right from our desks. Going through a browser like Internet Explorer or Navigator, we can search for information from thousands of sources using sophisticated technologies like Ask Jeeves and Yahoo. We can find interesting articles and interact with friends and family through AOL. I even recently read about a service started just last month called, I'm not sure how to pronounce this, Wikipedia, that might someday replace our home encyclopedias free of charge. My co-counsel, Mr. Melamed, has explained the barrier to entry that exists protecting Microsoft's monopoly. Navigator was knocking down this barrier and Microsoft knew it.
But wait a minute.
Yes, Your Honor.
Navigator is a browser, and the concern here is with operating systems. So what's the connection? I mean, it's not been, go ahead. What are you trying to tell us about Navigator that's relevant to an operating system?
Navigator lowers the application barrier to entry because it creates a capability that applications developers can use to execute certain functionality. And some of that functionality now can even run remotely. And in order for those applications to run, they no longer are entirely dependent on the operating system. They start to become more independent of the operating system. And once that happens, Judge Ginsburg, it becomes easier for them, the applications developers, who currently only develop for Microsoft's operating system, to develop in a way that makes those applications easier to use from other operating systems. That's what lowers the application's barrier to entry.
But it would be the same app, it'd just be portable, is that the idea?
Yes, Your Honor, but a lot less work for the developer to do in order to make it available, whether that's on Microsoft's operating system or on some new operating system that might be more innovative.
And the government's theory about this, right, is that Microsoft took several steps with respect to Internet Explorer and embedding it in its operating system that made it more difficult for people to use Netscape. That's your theory, right?
Correct, Your Honor.
Okay, so a couple of years ago in the consent decree case, this same court, warned against putting judges, quote, in the unwelcome position of designing computers. And, you know, when you look at the district court's decision here, he was weighing the testimony of a whole series of experts about all kinds of detailed aspects of the computers, the intermingling of the internet browser and the computer code, which he said he made a conclusion that jeopardized the stability of the operating system, or increased the likelihood. He made all kinds of technical decisions about this. It sounds like just what we warned against 3 years ago, isn't it? I mean, that's what we warned against in the consent decree case. Exactly what this district judge did.
Your Honor, we certainly agree that innovative companies should be allowed to design their products to best suit their customers, and that courts should not be too quick to second guess those judgments. However, that does not mean that antitrust plays no role in technology markets.
I totally understand that. I got that. I just don't understand how this court draws a line between, the proper examination of what's going on and the detailed examination of what this district judge did in terms of how Microsoft embedded its Internet Explorer into the operating system. It sounds like this is exactly what we were warning against.
Well, that's the role of the trial, Your Honor.
Well, how do we know that what the district court did here was on the proper side of the line and not intruding too deeply into the design of the computer?
Because what Microsoft did here was not competition on the merits. They did not improve their product. They did not improve the browser, at least the functions that we're talking about, and Your Honor's already alluded to, removing that option from the add remove feature, something that had never been done before and wasn't done for other software packages. Intermingling the code in a way that was unnecessary. Overriding the user's default choice for certain essential operating system functions. These things were not competition on the merits. They were designed, and Microsoft's executives even wrote this in documents. They were designed to make the use of Netscape's Navigator a jostling experience. Quote.
What do we do if we look at each of these three things that the district court relied on? And suppose we think they had two effects. That A, they improved the product, but they were also anti-competitive. What do we do with that?
I think a balancing has to occur at that point.
Right, but how do we balance it? We're the ones who have to do that. What do we do?
Well, I don't think I can anticipate every hypothetical. I think that's why cases come up and are judged on the trial records and the facts.
Let's take the intermingling of the code. There's strong evidence that had beneficial effects. There's also strong evidence that it was anti-competitive. What do we do?
Well, I think witnesses need to be heard. Credibility judgments need to be made.
I've done all that. Now what?
And I think the government should get the benefit of the doubt at the end of the day. Well, Your Honor, I do appreciate the challenge in trying to make this difficult judgment. However, Microsoft is wrong when they suggest that they have this carte blanche to come into court and assert that their product design features must necessarily escape judicial review under Section 2 The Supreme Court has described exclusionary conduct as conduct that not only tends to impair the opportunities of rivals, which this clearly did. The record is clear. Netscape precipitously lost share in sales and downloads and usage after this change was made. This is a change to the Windows operating system. So it impaired the opportunity of the rival and also either does not further competition on the merits or does so in an unnecessarily restrictive way. And that's the Aspen skiing case. The Kodak case, Supreme Court's Kodak case from 1992, further held that valid business reasons, and it's Microsoft's burden, which they did not do at trial, to come forward with these valid business reasons, that valid business reasons do not justify conduct that tends to impair the opportunities of a monopolist rivals, that conduct is exclusionary. The evidence at trial easily showed that Microsoft's integration of Explorer into Windows satisfied this test. Microsoft argues for a very difficult, even impossible, except in extraordinary circumstances, test that we would have to satisfy in order to show that competition was impacted.
So would you describe your test? I understand you think theirs is impossible, but what's the government's test that you think we should apply?
There is an absence of law in this, Your Honor.
Yeah, definitely.
I
noticed.
we came into work today.
Yeah, I noticed.
I'm sorry, Your Honor.
That's why we came
Yeah.
into work today.
There's a treatise that both sides argue about, but you're totally right. I didn't see any cases about this.
Yes, and the treatise is the well-regarded, authoritative treatise from Professor Arita.
Okay, but what's your standard?
Well, he explains the standard
What's the
as
government standard?
that the court can infer
Government standard.
an inference of anti-competitive effects and monopoly maintenance can be inferred from anti-competitive conduct, which has been established here. It can be inferred that violates Section 2 for monopoly maintenance, quote, when it reasonably appears capable of making a significant contribution to maintaining monopoly power.
Okay, that's a
There
quote
we
from
go.
Arita, right?
Right. So
Okay, go
let's
ahead.
stay with just that. So the question then just becomes whether from the findings that, or those that end up being upheld with regard to anti-competitive conduct, whether that is from that it appears reasonably from them that those acts were capable of making a significant contribution to maintaining monopoly power. An uncharacteristically weaselly passage from the Arita treatise, which usually cuts square corners. So tell us about the significant contribution to maintaining monopoly power here on the facts of this case.
Yes, Your Honor, and Judge Jackson made that finding, and I will summarize the evidence at trial. Microsoft itself recognized the threat that competing browsers posed to the barriers to entry that protected its monopoly. That's been established.
Okay, but that by itself can't prove your case.
Not by itself, Your Honor, I agree.
So what's
Microsoft intended its integration of Explorer into Windows to make the use of Netscape a jolting experience.
And what's the evidence? I know you think it did, but what's the evidence that they intended that?
It's in the documents, Your Honor.
Well, what are they?
The documents say that it is clear to executives at Microsoft that the other exclusionary conduct in which they engaged would not be sufficient to make a big dent in Netscape's attractiveness to users and computer OEMs. And therefore, it was essential to integrate it into the operating system and do what the company could to make that an unpleasant experience for users. There was an additional effect when they started removing optionality. Removing optionality has no conceivable pro-competitive justification. Removing optionality meant that for computer manufacturers who were shipping computers with with Microsoft Windows and Internet Explorer irreversibly installed, that if they wanted to install Netscape, which they had done previously, which they had judged as the better browser for their customers, they would have to maintain, install, train, and support for users 2 different browsers. That was a prohibitive expense for them, and in fact, the evidence showed that the proof is in the pudding, Your Honor. Their sales declined precipitously.
Somehow we got away from jolting the consumers. right? And
There's two parts, Your Honor.
So was the phrase you used, unpleasant experience, was that a quotation?
No, jolting experience was.
Jolting experience. So they want to make it a jolting experience for the user to switch to Navigator.
To use Navigator, even to use it, not just to
Okay,
switch.
so now how does that relate to the expense that OEMs would incur if they tried to support both browsers?
First of all, their products would be less attractive to consumers if they're jolting. And the problem the OEMs had, Your Honor, was they have to test their hardware. When they come out with new hardware, they have to test it on all the software.
I understand that, and that seems relevant, but not to the general theme here, but not to how that's jolting consumers.
Two different things, Your Honor.
Okay,
They're
so
not
one's for
necessarily
jolting
related.
consumers, the other is what?
That the computer manufacturers, the OEMs, and the evidence shows that this in fact happened, that they were discouraged to the point of no longer shipping Netscape, even though that's the browser they had judged to be the better browser for their customers. And that's the foreclosure that happened.
So why did they enter into exclusive arrangements with Microsoft?
I've been red buttoned, Your Honor.
Oh.
So
can answer the
we will
question.
submit supplemental briefing on that. Thank you very much, Your Honor. And we do ask that the court affirm the findings below. It's been a real privilege. Thank you very much.
Thank you, counsel.
For those who are new to Court of Appeals arguments and don't know what hot bench means. All right, thank you. I'm going to turn this over to Bill Barrett for our panel discussion as David Frederick and Maureen will happen to go and join the judges. Thank you. And Doug, to come back on screen.
Right. Well, Doug, welcome back.
Thank you, David.
Maureen and David, welcome today. As I do have to remark before I begin, that it is an unusual position, somewhat ironic, to be in the well and addressing questions to the judges on the dais. So
For us too.
it's a privilege, and I think it'll be a rare privilege on my part. All right. So before directing some questions to our panelists, I'm going to build a little on Doug Melleman's open scene setting presentation. This was, as he noted, a fast track case in district court, and as we'll discuss later on appeal, from a complaint filed in May of 1998. We went to final judgment 13 months later on June 7, 2000. There was a finding of liability by Judge Jackson that largely accepted the government's substantive proof. And on remedy, he adopted, almost without change, the DOJ proposal to split Microsoft into two companies, an applications company and an operating systems company. He did it without, as Doug noted, an evidentiary hearing. Then, we haven't talked about this yet, but shortly after Judge Jackson's ruling, stories appeared in the New York Times and the New Yorker reporting on conversations the district court judge had held in chambers with those two news organizations while the trial was going on. To say the judge's remarks were candid and controversial understates by a fair amount. So here we have the biggest Justice Department state AG monopolization case in decades. In the fast-paced technology sector, we've got an extensive record below. We have liability found. We have an order from Judge Jackson breaking up Microsoft into two companies. And on top of it all, we have this extensive out-of-court commentary by the district court judge about the company, its executives, and its lawyers, and his view of the evidence. So, Microsoft didn't waste time. A week after the June 7 judgment was entered, Microsoft filed its appeal. And I think I have this right. Within 1 hour, the Court of Appeals issued an order that the case would be heard en banc. Now that's a little unusual, unprecedented, and that's where I'd like to begin if Judge Tatel and Judge Ginsburg will allow. What's the backstory on how this case went en banc from the get-go?
Do you want to go first? Go ahead.
Well, I don't recall the 1 hour feature of this, although you may be right. But at some point, shortly before the order issued, there was a discussion as to whether to do this. This question arose: should this be heard en banc from the outset? And it was discussed, and there were two reasons offered for doing so. One was that the case was of great importance, and the only precedent, I believe, was the Nixon tapes case. The other argument, and that seemed to me to set up a non-standard. The other argument, which I agree with and surfaced at the discussion, was this. This was a court of 7 judges.
Right.
We were 11, but 4 were recused. And if we had a decision with a panel of 3 drawn from a court of 7, under the rules as they then existed in the Federal Rules of Appellate Procedure, a petition for rehearing en banc would require a majority vote of all active judges regardless of recusals. So that would require 6 votes to overturn a panel decision that, even if it had a dissent, involved 2 out of 7, thereby preventing more than 5 from voting for rehearing. And to me, the idea of a panel of 3 faced with this enormous case should not be, which by the way was in no condition for Supreme Court review. It was totally unprepared for that. The case was not ready to be reviewed by the Supreme Court. And to have 3 judges and no intermediating discipline by the potential for rehearing en banc was a mistake.
I'll just add one thing. The reason it only took an hour is that this was not a hotly debated question. I mean, it seemed obvious to the 7 of us instantly that because of the importance of this case and the fact that it would inevitably go en banc anyway, that we would be providing a much better service to the country by hearing it en banc in the first instance, and provide a better basis for ultimate Supreme Court review if that was necessary. It was not a difficult question for us.
Thank you.
The record in this case was 70,000 pages.
Right.
Somebody, I presume Microsoft, had gratefully for us digitized the record so we could search it. They couldn't digitize in that stage of the technology then the graphical exhibits, which was a significant drawback. But 70,000 pages, a very large number of issues, hundreds and hundreds of findings by the district court, and almost as many conclusions of law. And to throw that into the lap of the Supreme Court, they couldn't possibly deal with it. They would have to send it back to us.
There's one other development that I think most people who watch this case have probably forgotten, that I thought was quite fascinating, was shortly after we issued the en banc order, we also issued an order announcing that we would have a technical briefing of the court. I mean, the 7 of us didn't know a whole lot about this technology. As Judge Ginsburg said, this was a complicated case, and it was a technology few of us knew anything about. So we had this idea of appointing an expert. He was from the Illinois Institute of Technology, I think, to come to the court with representatives of each party and give the court a technical briefing. Start with what's an operating system, and just brief the court on the technology separate from the legal issues. And that order gave the parties a week or so to respond. Well, the parties were, to say the least, not pleased with that order. They made it very clear that they thought you could not separate the technology from the legal issues. And so we dropped the idea and ended up relying on our law clerks to figure out the technology.
That's not the first time that's ever happened, I suspect. So let me move to David Fredericks. You, at some point after the en banc order was issued, there was a scheduling order of oral argument. And instead of a few minutes aside, it was 2 days with issues, substantive issues separated out. How did you react to that? And then how did you prepare to advocate on behalf of the government?
Well, I want to first say that the advocates today did a marvelous job with a hot bench, and I will say that it was even hotter for the 2 days that we argued. My partner Jeff Manier from the SG's office, who argued the monopolization part, he faced, and I actually counted this, almost 200 questions in 75-minute segment. And it was that way for 7 hours. It was, literally 2 to 3 questions a minute. And we mooted like crazy. We had an incredible team at the Justice Department who went full bore into this. And I just want to call out so that you all know, whenever you do something like what our advocates did today, there's an enormous team behind you. And Phil Malone was an incredible architect of this case. He knew every exhibit. He knew all of the facts cold. We called him anytime, day or night, and he was responsive. MJ Moulton-Bray was an incredible font of wisdom about how various aspects of antitrust law should interface with these facts. Kathy O'Sullivan, Bob Nicholson, Susan Davies, David Seib, Adam Hirsch at the appellate staff were there. And we, I guess there were 5 segments. We probably did at least 15 moot courts combined, where we had to practice the equivalent of standing in a batting cage and having balls at 100 miles an hour. And instead of having a limit to the number of balls, they just kept coming. And that was essentially what the argument was like. And I hope it was helpful, because it sure was challenging and really difficult. The other innovation that the court imposed on the parties was to provide briefs in an electronic form that created hot links for every cited material in the briefs. The briefs were 150 pages each side. There were 15,000 links in the briefs to cited materials. The judges sitting up here were linked to their law clerks by computer and a laptop. So as we stood in the well to argue with our paper binders, there were 14 people who had electronic access to all of the materials. It was terrifying. I'm not kidding you. It was terrifying because we had to know as much as we could know about everything. And as Judge Ginsburg said, it was a huge record, and this material is not easy to grasp with software code, interfaces to products, licensing agreements. There was a copyright issue that Microsoft raised. There were a whole slew of challenges, not to mention the remedial hearing problems and very difficult questions of antitrust law. So Jeff and I spent the better part of 6 weeks getting ready for the argument. And we were ably assisted by John Roberts, who was the premier appellate lawyer in the bar then, who was representing the states and who we persuaded to take on the very difficult challenge of explaining why the errors that Judge Jackson had made with respect to his discussions with the media and other trial features should not upset what we all recognized was the largest strategic objective that we had, which was to preserve the monopoly maintenance liability finding. We knew that there were aspects that could not be defended of the judge's ruling, and so the entirety of our presentation over the 2 days was in service of preserving the liability finding.
Thank you. Maureen, you had just, I think, completed a clerkship for Judge Centel. You had a luxury box seat as fastballs were being thrown
Yes.
on the batters, or advocates, I guess is the right term. Give us your sense of what it was like in the courtroom those 2 days.
Yes, that was, I think, the hottest ticket in town, particularly. I mean, it wasn't just for antitrust nerds, right? I mean, I was really fortunate. I was a young antitrust lawyer. I had clerk for Judge Santel, and I believe the judges all got 2 tickets, maybe, for people to attend. Like you were able to, it was restricted. So Judge Santel very kindly gave me one of them. He gave his brother-in-law the other one. So I was very fortunate there. It was just like fascinating to watch, particularly someone who was an antitrust. Judge Ginsburg was my antitrust professor. I was still early in my career, and it was just fascinating to watch the level of argument, the level of questions. I believe it maybe was one of the first times, if not the first time, that the judges did have those links, the digitized documents, and it was really interesting to see how that played out as someone who had sat through a lot of oral arguments with paper briefs and paper records. And it was just, so fascinating to see. And then to have the decision then issue so shortly thereafter was also really, really fascinating, and as a per curiam decision as well. So it was just, I still feel so fortunate to, early in my career, and those of you who are here who are law clerks, you may someday, you might have a case that you sat on or you helped your judge on, and then, or you get to watch, and then it becomes this like core part of your practice. So to have seen it in person was just so exciting.
Thanks. And you mentioned the per curiam opinion. That's where I wanted to go next. On June 28th, the court unanimously found for the government on certain of the Section 2 monopoly maintenance claims, and rejected other of the lower court holdings on attempted monopolization, on tying the browser to the operating system. And also in light of those findings and for other reasons, including the judge extrajudicial conduct below, returned the case to the district court and ordered that a new judge take over the subsequent hearing. The question I guess I have for the two judges is, how did you get to the point where you decided you would have an unauthored per curiam opinion?
Well,
of some length.
Well, this was, I think, Doug agrees with me. I think the 7 of us who were on that panel, we look back on that as, a high point in the history of the DC Circuit, and frankly, of most federal appeals court, to produce that opinion in that amount of time. But we had a leader, and our leader was our Chief Judge, Harry Edwards. And if you want to understand the role of leadership and how institutions function, you need to look at the Microsoft case. The first thing, first of all, you need to know that this was the case of the century. You had 7 judges. Everybody wanted to write this opinion, right? I mean, I was a junior judge. I had no hope of writing this opinion, but I still hope, it might happen, right? So we get into conference. We have 7 people who want to write the opinion, and Harry Edwards says, we're going to all write this opinion. And he divided it up among the 7 of us. That's how that all happened.
I would just say as a prelude,
Yeah.
Harry had become
Right.
chief judge in 1993.
Right.
And in 1994, I would say, he had complete command of the court.
Yes.
The confidence of all of the judges. So that our administrative meetings, which had immediately, when he became chief, gone from once a month to once every other month, thereby winning applause, they typically ended, he would introduce some issue that needed to be resolved. And after his presentation, somebody, usually Judge Silverman, would suggest that the chief resolve the issue when the time came and the way he sees best. That's how
it worked. Thank you.
complete his leadership was.
Well, let me just add 1 or 2 things as to what happened here. So Harry divides it up among 7 of us. We each get an issue, and everybody goes to work on their respective portions of the opinions. And then we start circulating them. And we had a schedule because we did want to get this done as quickly as we could. And we would circulate our portions just as if we were circulating an opinion to the panel. It was the same way. And people would comment, and the judge whose portion was issued would then revise it. And I would say that if we had tried to issue an opinion 2 months after oral argument, there might have been 7 different opinions, and it would not have been unanimous. But what happened in the process was that as the opinion circulated and as judges discussed it and shared memos among each other, issues were resolved, they were discussed, and everybody got closer and closer and closer. There was intense negotiations over some issues between some judges and all judges, all under some very effective leadership, and it produced quite a dramatic result, which was that unanimous 125-page procuring opinion without a footnote.
Right, exactly. Let's write that. Let me go next to Doug and then David. You saw this decision. You read it and reread it. What were your reactions in terms of how much the government was able to get out of the case it had brought? Doug.
Well, I thought it was a great fit for the government. Largely because, as David said, the core issue was always monopoly maintenance theory. And it was a big victory on that. I'll come back to that in a minute. The issue is how much the government lost, the legal theory about tying, with a very creative resolution by the court that, much to my surprise, has not been emulated in an effort to sort of erode the so-called per se rule against tying. The attempt to monopolize, we hadn't defined a market properly, that's not surprising. The remedy order of the judge was indefensible. There's no way that was going to stand. So we thought it was a great victory. And the principle, a couple of reasons. One is almost every, but one of the 2 or 3 of the exceptions, every aspect of Microsoft's conduct that the federal government alleged to be illegal was found to be illegal. That's sort of a good starting. But I think the opinion was magnificent. It was a synthesized in a coherent, accessible way, a wide body of law. It made a number of explicit doctrinal contributions that are important. We heard a conversation earlier about the causation and injury to competition requirements. And there are a number of others we can talk about if we have more time. And it made a lot of implicit contributions in the way it approached the issue, things that were not entirely new. I said in my opening that the government didn't paint with so broad a brush. I have since become to say that antitrust is about microsurgery. And I think this opinion was exemplified microsurgery at its best. So I was out of town, so there were no other team members around, but I was celebrating what I thought was a great victory.
David, anything to add to that?
Well, Jeff and I were colleagues in the SG's office, so I went excitedly down to his office, and we resolved immediately to go to the local beer hall to have a pint where we would celebrate. And one of our law colleagues came along and said, "Oh, but it looks like the government lost, are there going to be cross petitions for cert?" And I said, the only cert petitions that's going to be filed in this case is by Microsoft. It's not going to be by the government. We knew from the get-go that the issues that we eventually lost, we were going to lose and we should lose. And the thing that was really so exciting about the way the court resolved it was that it did it without embarrassing the government. In ruling against rulings that were just not sound. So we were really excited. It was a great moment.
Thank you. So, Maureen, after clerking and being in the courtroom for 2 days, you ended up a little later on in career at the FTC as acting chair, and before that as a commissioner. And so you have this significant addition to Section 2 jurisprudence. Tell us a little bit about how the government used the Microsoft decision in making its future enforcement decisions and then litigating?
So while it was I think, a very incredibly important precedent, really functions like a Supreme Court precedent. All the circuits look to it. It's very, very well regarded, relied upon. It didn't really lead to a big flood of government Section 2 enforcement. I think particularly on some of the product, design issues and things like that, where it has been used, I think effectively, and in some ways it gets a little less attention in Section 2 enforcement, is on the distribution restrictions that were found illegal, the behavior involving raising the cost for rivals by having the equipment manufacturers, right, not be able to distribute competitors' products, efficiently. And so there's a case, when I was at the FTC, a case called McWane, which was, I think, one of the first exclusive dealing cases that the FTC has brought in a very, very long time. And the question was whether, the agency found liability for a company for engaging in exclusive dealing, and it raised all these similar kinds of issues. Another competitor was in the market, but it really wasn't flourishing. It had been kept to very low market share. And these questions that Microsoft helped decide really then were a good foundation for the FTC's decision, finding liability here over a strenuous dissent of a fellow commissioner, ended up being upheld in the 11th Circuit. And it was a very big step forward, I think, in this kind of case law. We saw also a little bit of the product design issue, not so much in the federal government, but in a case called Namenda that has to do with design for pharmaceuticals, whether there's a design to take a drug off the market and then foreclose a generic competitor getting in, and was that kind of a use of product design in a way that was anti-competitive. So, but on things like duty to deal with rivals, the government enforcement in that area relying on Microsoft has been much less, I think, successful. Think about the Qualcomm case in the Ninth Circuit. Even though the government, the FTC, argued, relying on Microsoft, the Ninth Circuit just didn't find the parallels the same. So it's been interesting. I mean, it's a very, very influential case, but it hasn't really led to a whole spree. I mean, we'll see. There's a bunch of stuff in process now, I would say.
I've heard of them. Yeah.
So we'll see. We'll see what happens. That history is still being written.
Fair enough. Judges want to comment on that?
Yeah, just that it seems to me that in the intervening 20 plus years, the feature of the case, Microsoft case, that seems to recur so frequently in the case law is the allocation of burdens for a Section 2 case, which only after it had issued, in fact long after, did it occur to me, had an intuitive appeal, I think, because it was essentially parallel to the allocation of burdens Supreme Court had laid out in McDonnell Douglas for Title VII employment discrimination cases. They really line up. And again, I think it only really came to see that later on.
But because of the technical issues involved in how the software code would be written, the interface of other application software, it makes perfect sense in the context of the problem that we were all trying to deal with, which is a bunch of people innovating in a range of different spaces where there's an intermedium and there are a lot of different inputs. And so figuring out what is pro-competitive, what is innovative, and what is exclusionary conduct does require, that kind of analysis of what is being sought here, what is being excluded here, what are the justifications for doing that?
Yeah, no, that's right. I mean, I think the situation elicited that response, not some pre-existing work from the Supreme Court.
All right. But what happened on remand? Well, to make sure we complete that part of the story, the precedent is there and is is quite useful. But as Doug Melliman indicated earlier on, there was an election. Elections have consequences. A new team came into the antitrust division and pretty quickly made it clear they were not going to pursue structural relief as an option, and entered into a series of conduct restrictions preventing Microsoft from placing certain limitations on what middlemen or middleware producers could do, set up some compliance obligations. And one of the things in preparing for this argument we talked about a little bit is there's not been a lot of study, systematic study of the impact that actual remedy had on the affected marketplace, with one exception. Maureen edited an antitrust law journal piece about 5-6 years afterwards, and where that was the question presented, what is the antitrust consensus, which we all know is an oxymoron in the antitrust world, on what impact the consent decree negotiated between Microsoft and the government had on their marketplace.
Yeah, so this was an American Bar Association symposium held in 2008, and the papers came out in 2009. And I think the consensus, to the extent there was one, and Carl Shapiro wrote a key paper on this, was that the remedies, at least at that point, hadn't been very effective, right? That the remedies that were imposed really hadn't changed the calculus very much. I think there are challenges, right? When you have these issues involving trying to undo issues that happen to nascent competitors, but technology continues to evolve. I think that was some of the challenges. Now so that was 2009. Now we're in 2023. I think it's a little hard to tie back to the remedy, but the market has really changed, right? When you look at Microsoft's, it doesn't even have a browser anymore, really. It still has a very high share of the desktop operating market, but desktop is certainly only one portion. And when we look at we look at phones and we look at tablets, Microsoft really doesn't have any presence there. Can you tie that back to those remedies? I think it's really hard to say. I do think, though, that the parameters that were put down by the case have helped, certainly I know as an antitrust counselor myself, set some of the guardrails for new players who've come onto the market who are dominant or who want to become dominant for what they are allowed to do or what they think is appropriate to do. So it does have that, I think, benefit, but ultimately, did the remedy fix it? It's a little hard to tell, and it's always a challenge, I think, to put the genie back in the bottle on something like that.
For me, having been an enforcer and been part of, I think, a bipartisan view, concern on the part of enforcers about the limitations of behavioral remedies, regulating a market, the challenges of structural relief, which more often come up in a Section 7 merger context. I was impressed by that part of the introduction to the opinion that showed some humility about what to do, either structurally or behavioral, in a fast-changing market, in a market where I think the opinion says Microsoft's growth to a dominant position was organic. It was not through acquisitions. I don't know whether judges want to talk about that part of it at all, but it remains a challenging dilemma for enforcement and for the courts.
Well, I have to say that maybe this was because of some of the testimony in the record. I can't remember, but I certainly wondered whether, why don't we just wait a few years and that'll take care of the problem. Technology will solve this. I certainly wondered about that, but that obviously wasn't an option for the court, but I know quite a few of us had that in mind.
Well, one aspect of the remedy was the appointment of a monitor for 10 years, and I think that was extended ultimately to 12.
It was 5 with an option to go 5 more, and I think they ended up extending 2. So it was a total of 7 years, if I remember right.
So I've seen observers saying that period unleashed a huge degree of innovation and market entry that might not have been possible had Microsoft not been under these behavioral inhibitions. And others claiming that Microsoft became much less innovative and creative during that period because of the micromanagement or monitoring. It's both plausible, I suppose. I had a law clerk once who had a summer job at Microsoft and who became a proponent of the second view. He said, no meeting could start until someone showed up from the counsel's office. And it was not a healthy way to run the company.
Understood. Listen, we've got a few minutes left, and what I thought might make sense is to ask each of you if you've got a few concluding comments. And if it's okay, we'll start out in Palo Alto, California. Doug, what do you got to say?
Let me just say this. There's not much to be said, but I want to pick up on something on the remedy question. I certainly agree with skepticism that expressed in a variety of ways, including by you, Bill, about conduct remedies. But look, antitrust remedies serve four purposes: compensation, ending the unlawful conduct, preventing its repetition, and deterring, and then restoring competition that was injured by the violation. The conversation about whether the Microsoft remedy was effective goes only to the last of those four objectives. And I think it's overrated. I mean, we prosecute murder cases even though we can't resurrect the corpse. And I think it's really important to understand what Microsoft did accomplish in terms of establishing new law, demonstrating that the antitrust laws can apply to technology industries, exposing Microsoft to all sorts of class actions and other damage remedies, prohibiting a continuation of the conduct specifically found to be unlawful. So I think with respect to the broader purposes of antitrust remedies and the evolution of the law, it accomplished a great deal, even if the restorative remedies were not particularly effective, or even if to some extent they were counterproductive.
Thank you. Maureen, concluding comments?
Sure. Look, I completely agree with what Doug just said. The other thing that I would just say is if there are any nascent antitrust lawyers out in the audience, just to say it's a fascinating field. I think it's one that I couldn't have enjoyed more in my career. And this opinion was just such a fantastic achievement of such careful thought. The government's case, Microsoft's case, the careful opinion of the DC Circuit, and I think it just speaks to what a fascinating field antitrust is. So it's just a more general point.
The sales guy. Good.
Yes.
All right, David.
This is hard for me to conceive of the right set of words because it was a seminal event in my career, and it was a searing experience to be part of something that was so big, and yet to be a team member and to have a role and to expect everybody to execute their role and to be able to watch the DC Circuit operate with such effectiveness and precision was really an awesome thing as a younger lawyer to watch, and to see it in a context of rapidly changing technology where there were great aggregations of power that were literally happening very, very quickly. My head still kind of spins when I turn the clock back 22 years to conceive of how all of this happened, so rapidly. And it was really quite an accomplishment for the court, and I feel really privileged to have been able to be in the well and presenting to the court. It was a great, huge honor.
Thank you. Judge Ginsburg.
The case was very well presented on both sides. It was a terrific aid to the court to have that quality of input from counsel in the briefs and in the oral argument. Everyone geared up for this, the court and both of the parties, in a way that was proportionate to the stakes and the issues, and that made everything else possible. As you know, Bill, there's a body of theoretical literature on both sides of the question whether monopolies are more or less likely to be innovative than a fragmented market is, and some conflicting empirical literature as well. And I think it's kind of an interesting fact that over the years, at least after the monitoring period, Microsoft still has an enormous market share in operating systems and continues to innovate. It improves if it didn't compete against itself, against its embedded base of computers with running Windows, it would have no revenue. And so it's constantly improving the product in order to make sales and get new sales from people, and ultimately give up supporting old versions of the operating system. And on the enterprise side, it's gone to a subscription service, so it's literally constantly improving the product, not just every so often when we get a new version of Windows. And I think that deserves a lot more inquiry than it's been given.
Thank you. Judge Tatel, I think you, either on the briefs or in argument, you had a future colleague, Justice Roberts. I believe Judge Bork was on the briefs. And at least one other, Ken Starr, Judge Starr, all were in on behalf of the government side of the case. Any recollections of their involvement? Any other final thoughts?
I'll just repeat what my colleague here said about the arguments. They were all quite superb. I mean, we worked really hard to prepare for it, but I have to say we were enormously helped by the quality of the advocates. But I want to say something not about the antitrust laws, but about the court. I've already said how proud all of us are for having produced what we did, but I think what we did was especially significant when you look at our courts today. At Supreme Court, appellate courts, increasing divisions along ideological lines for the past 8 to 10 years. More and more 5-4 decisions, divided decisions of courts of appeals. The 7 of us were, 4 were appointed by Republican presidents, 3 by Democratic presidents. I have no doubt that if the 7 of us sat around and talked about our views about how the antitrust laws should apply to Microsoft, you would have had 7 entirely different views. But the court functioned as a court, not a bunch of policymakers. And the 7 of us, by listening carefully to each other, by respecting each other's views, and by debating everything on the merits and not personally, produced a completely unanimous, clear opinion. And I think that's a great model for what judging should be.
So those are great conclusions. Thank you, panelists. Let's give them one more round of applause. I believe Jim has one more.
So thank you, everybody who participated in the program, everybody who came to the program. It's been terrific. I should add for everybody, some people who don't know, Judge Colarcatelli is here, who got the case after. Right, exactly. So we are recessed at this point. I think I can say that. And there is a good food and good drink down in the atrium in the Bryan Annex, and we hope to see all of you there. Thank you.